Hi everyone, my name is Shalhevet Schwartz, and this is Gefet Ep.86, a joint project of Hadran and Yeshivat Drisha. The sugya that we will be dealing with today, really the concepts that we'll be dealing with today, the concepts of Gerama and Garmi, two different terms that refer to damage that is caused. That is caused in indirect fashion. So it's not that I come and bash your computer with my bare hands, but the kind of damage that is done in a sort of roundabout or indirect way. I somehow cause a damage that makes it impossible for you to collect on a loan, let's say. Um, and really the question that the Gemara deals with is the question of what is, right, halacha's relationship to those kinds of damages. Can we enforce liability on the part of the mazik in those cases? We will begin with the Mishnah in Bava Batra, that a Mishnah in Bava Batra that presents us with two different cases. Right, we're dealing with dinei shchenim, with the ways that with laws of neighbors and their responsibilities to one another. So, right, the Mishnah says, "Marchikin et hasulam min hashovach arba amot kedei shelo tikpotz miyah." So, someone, right, you've got two neighbors with houses next door to each other. And one of them wants to build a ladder, right, adjacent to the other one's house. So they has to keep it at least 4 amot from a shovach, a dovecote, kedei shelo tikpotz miyah, so that a weasel couldn't jump from the ladder to the dovecote, causing damage to the neighbor's dovecote. והכותל מן המזחילה 4 אמות כדי שיהא כפל הסולם. Right, so similarly, someone has to keep you have to keep your ladder 4 amot from the gutter of the second house, so that the person, right, who owns that other house, owns the house with the gutter, um, can have access to his gutter to do repairs, to empty it out, etc. Right, two cases that on their face seem kind of parallel, right? We're dealing with, right, two people who have houses next to each other. A person who wants to build a ladder has to keep a safe distance from the other house. So, right, structurally the cases look very similar, but actually conceptually, there's an important, right, they seem to be pretty distinct. Right, the first case, right, the first case really is dealing with the laws of benizakin, which is to say, that the reason why I have to keep my ladder far away from you, very far away from the second person, is to prevent a situation in which I indirectly cause damage to the owner of the second house. Whereas the second case really seems to be about the laws of kinyan, about owners' rights, and what is air rights, essentially. What does it mean to have access, right? If I own the house there, I need to have access to be able to kind of deal properly with what's going on in my house. So despite the fact that the two cases here look relatively similar, they actually seem to be dealing with two different kinds of things. Right, and the first one, we're dealing with indirect damage, right, gets us to, right, a concept of grama, which shows up also on in our sugya on Daf Kaf Dalet. So, right, the sugya on Daf Kaf Dalet, it brings a story about Rav Yosef. Rav Yosef hava lehanhu tale dehavu atu omne v'yat ve'tutayu. So Rav Yosef had tale, had palm trees, which omanim would come. Omanim are artisans, but in this particular case, it refers to people whose work was bloodletting. So it was a kind of medical professionals, and they would come and sit under these palm trees. And what happened? Adu orve. So ravens would come because they were dealing with blood. There was, right, bloodletting going on under these trees, and the ravens would come. Achle dama. They would come to eat the blood. Visalke abetale umafsedetam. Right, and they would, right, come to feed on the blood, and then they would sort of go they would go up the trees and would consume some of the dates, and would that kind of caused financial loss to Rav Yosef. Amar Rav Yosef, so Rav Yosef would say to these artisans, these bloodletters who were sitting under the tree, Afikuli kor mehacha. So get out of here, because you are causing damage to my palm trees. Amar le Abaye. Right, Abaye says to Rav Yosef, V'ha gramahu. What are you talking about? This is grama. Which is to say, the damage that is happening to the dates, right, is not happening directly, right, via the presence of the omanim, of the bloodletters. Rather, right, their presence makes it the case that these ravens come, but the ravens are the ones causing the damage. So you have no, right, it seems like you have no right to force them out. Amar le, Rav Yosef responds, Hachi Amar of Tuvi bar Matna. Right, thus says Tuvi bar Matna, Zoto married Grama benizakin assur. Right, Grama benizakin. Right, even this kind of indirect roundabout damage, right, which we know that, right, the Gemara is making the assumption that we know that in cases of indirect damage, the mazik, the one who causes the damage, is not chayav to pay, is not liable for the damages that he caused. That said, according to Rav Tuvi bar Matna, right, Grama benizakin is still assur. Right, so right, just because the mazik isn't liable does not mean that he's allowed to do it. It's assur to cause that kind of indirect damage, even though one's not liable, and therefore Rav Yosef has every right to kick out these omanim. Question becomes then, right, if Grama benizakin is assur, then what really was Abaye thinking when he said that it's Grama? Right, the fact if Grama is assur, then it shouldn't be the case that he really had we shouldn't have any problem with what Rav Yosef is doing. So that's where Tosfot enters the conversation. So Tosfot starts by saying, what was it that what Abaye was thinking? And he just gives us a rationale for Abaye's havamina meikar salkadetach ki hechi de meikar patur hachinami mutar. Right, given that Grama benizakin is patur, right, given that you can't be held liable for damage caused through Grama. So Abaye's thought process was that if one is patur from Grama, then it should also be, right, it can't be assur, right, there it must be permitted or at least, right, not the sort of thing that one can prevent another person from doing. Right, and theoretically, right, that right, when it comes to tort law, right, it does seem a little bit difficult or kind of conceptually challenging to say that something is patur bal assur, and so that at least according to Tosfot was Abaye's havamina. It's actually Abaye's havamina makes a little bit more sense when we look at, right, in light of actually the Tosefta that's parallel to the Mishnah that we saw. So, right, the way that the Mishnah was framed, right, and the way that the Mishnah framed the two cases, right, as we saw, there was one case that looked like it was about, right, it was about Inyan, it was about where owners' rights and property rights and how they sort of how much the owner of a house has the right to access as well. But then one of the cases was about something conceptually totally different, and it sort of al haderech kind of entered into the conversation. That there's also not only an assur of causing damage via Grama, but that the owner of the first house has the right to prevent his neighbor from coming close enough to potentially cause damage via Grama or in this indirect way. But the Tosefta's parallel actually frames both of the cases, right? Both the requirement to keep the ladder away from the gutter and the requirement to keep the ladder away from the dovecote as pertaining to the laws of Kinyan. So the reason to keep the ladder away from the dovecote is Kadesh Yehezu Gefet Ep.86, right? Is so that the person will have access to the sulam and to keep it away from the maschila, from the gutter, is so that the person will so that the neighbor will also have a place to plaster and to deal with his own property. But in both cases, according to the Tosefta, it's not about, oh, will an animal be able to make it onto my property and cause me damage in some way, but it's about making sure to leave room for the owner of the second person's house to have access to his own property. So, right, why might that be? We don't know why it is that the Mishnah and the Tosefta look different, but why it is that the Tosefta leaves out this assur of causing damage via Grama, or at least the assur being close enough so as to potentially cause damage via grama. But maybe, right, the Tosefta doesn't, right, maybe according to the Tosefta doesn't holds like Abaye's Havamina, right? Maybe it's the case that within the logic of the Tosefta, the fact that grama is something for which you cannot be held liable might actually make it the case that grama that we can't force someone that we can't force someone not to cause damage via grama, or at least certainly that grama isn't considered a big enough concern or something that the second party could be liable for enough to cause him to remove his ladder or to distance his ladder further from this first person's house. Returning to our Tosfot though, so Tosfot's next step, right, as now that he's entered kind of the conversation about grama, is to bring us a whole slew of cases throughout Shas, in which we know that grama benizakin is patur. So, for example, right, the first case on Tosfot's list, Tosfot brings 10 cases, is a case in Parak case at Aregla and Bava Batra, of someone who throws something off of a roof, right? But at the moment when he throws the thing off the roof, there are right? There are pillows or something on the ground such that when the kli falls, it wouldn't have been damaged. So when I throw it, I'm not really causing the kli to break because it's safe, quote unquote. But then someone comes and removes the karimuk or someone removes the pillows, even if the person who removes the pillows is in fact the same person who threw the thing off the roof. You'd have to be very fast. The kind of logistics of this situation are a little bit difficult to imagine, but I throw the thing off the roof when there are pillows, and then somehow within the amount of time it takes for the object to fall, I also manage to remove the pillows. And therefore, the kli hits the ground and breaks. So that's considered to be a case of grama benizakin because all I did when I removed the pillows, right, I didn't actually, right, that was the thing that made the difference in order to cause the damage to the kli, but all I was doing was removing pillows. I wasn't actually breaking my kli, that kli b'yadayim. That's one example of grama. Another example, number 5 here, is poris get b'fnei behemat chavero. So if there's an animal that is, let's say, in a pen or in a cage somehow and is therefore not able to cause damage, and I basically make a hole in the fence, breach the fence, such that the animal can then go and cause damage. Right, I'm not considered liable for the damage caused because it's considered to be damage caused in grama. These are just two examples, but then this whole long list of cases the Tosfot brings, all of which, right, these are cases of grama according to Tosfot, and these are cases in which we know that the mazik, or the person who's sort of in the position that's closest to that of mazik, is exempt, is patur. Before we move on to kind of Tosfot's next move, and I want to just take a brief pause to look at how kind of the concept of grama, which we know is patur from the sugya, develops kind of throughout the thought of the Rishonim. Right after the first step that we have, right, even in the Havamina of Abaye, and maybe even in the Tosefta, the idea that, right, we know that given the patur, there might not even be an assur of causing damage via grama, causing damage in this indirect way, right? We see that then, right, kind of the next move is Rishavi bar Matna saying, no, I know it's patur, but there still is a prohibition, there still is an assur, and there's even a kind of a requirement to, even an ability a requirement to distance oneself from situations that could result in grama damage, right? The right of, let's say, Rav Yosef to kick out the Omani from under his trees, and that's sort of step one. We see the Maharshal saying that actually, even though someone who causes damage by grama is patur, they would still have to pay in order to be yotzei shamayim, meaning they still, right, that Beit Din can't force them to be liable to pay, but in order to be yotzei shamayim, in order to kind of fulfill their like spiritual obligation in some sense, right, they would still have to compensate the other party. Right, another opinion brought in the Maharshal is that Beit Din, even, right, is that sure, Beit Din can't force the person to pay, but Beit Din can put serious pressure on the mazik to compensate the nizak for the damage caused. And there's an opinion, right, in the Meiri, that someone who causes damage via grama, and if he refuses to pay, right? Sure, Beit Din can't force him to pay, but he does become pasul edut. He becomes invalid to provide testimony in the future, meaning he's not considered a trustworthy or upstanding citizen. Right, so we see even within the world of the Rishonim that that despite the fact that Grama benizakin is patur, that there still is a tendency within, right, a tendency to push towards liability, even if you can't get 100% liability. And we'll see kind of how that develops throughout, right, through the kind of next stage that we're going to see in Tosfot's argument. Let's return to Tosfot. Right, so we saw, right, Tosfot part 2 brought this whole list of cases when Grama benizakin is patur. Tosfot asks now, right, so now we've got a question, which is, what's the difference in all of those cases that we just saw? And, right, this different concept called dina de Garmi, right? Or this certainly different phrase used in the Gemara of dina de Garmi, which is a number of cases or a number of broad and different sugyot in the Gemara, where there also seems to be, right, uses the word Garmi, not Gerama, but a similar word, and seems to be referring to a similar kind of case in which there is damage that is caused in some sort of indirect fashion, and yet in those cases the Gemara, or at least a shita in the Gemara, at least a shita of Rabbanit, is mechayev, right, holds the mazik liable in those cases, right, and gives right, and similarly here brings us a number of different sugyot, in which we're mechayev for Garmi. So, right, one example is an incorrect evaluation of a coin, right, evaluating it at a higher price, and then it ends up being worth less. Another example is assur shtarotav shel chavero, example number 5, right, which is, let's say I lend a couple $1,000s to someone else, and I'm holding a shtar that says that person owes me a couple $1,000s. Right, a third party comes in, burns my shtar, which means that now I'm unable to collect on that loan. So I lose out on a couple $1,000s. So I can be, right, that in a case of assur shtarotav shel chavero, through dina de Garmi, we can be mechayev the person, right, we can hold liable the person who came and burned my check, basically, to compensate me for the money that I now can't collect. All right, so, right, Tosfot brings this whole litany of cases in contrast to all those cases in which we saw that are Grama benizakin, and those are patur, and yet here it seems to be similar kinds of cases, and yet there's where there's liability here. So Tosfot, right, first brings the opinion of the Ri, who tries to bring in kind of options for conceptual distinctions between the cases that are known as Gerama and are therefore patur, and the cases that are known as Garmi and Chayav. So the Ri offers two different conceptual distinctions. Number one, right, lashon achad dina de Garmi Chayav hainu she'oseh hu atzmo hezek lemamon chavero, right, that the difference is like the Garmi cases are the cases in which person A, the mazik, is the cause of, albeit indirectly, of the mamon of person B, right, as opposed to these cases in Gerama in which they set in action something that causes another party or another gorem, right, an external cause that's the actual cause of the damage. So in the case of, let's say, the bloodletters who are sitting under Rav Yosef's tree, it's not the bloodletters themselves causing the damage. It's the ravens who are causing the damage, and the bloodletters' presence is the thing that is causing the ravens to come. But the bloodletters themselves aren't causing damage, as opposed to assur shtarotav shel chavero, where I'm coming and I'm burning your shtar. I am kind of physically causing, right, performing an action that is causing that, right, that's causing the damage. Albeit indirectly. So that's chiluk number 1. Chiluk number 2 that the Ri tries to make od chilek dina de Garmi chayav, right, hani mishat ma'aseh sheba hezek, right, that it's a distinction, right, a temporal distinction. The Garmi, the nezek, right, the damage is caused at the moment when the mazik performs the action that the mazik performs, right, where there isn't a a time lag or a time gap between the mazik's action and the nezek that is caused. Right, so these are two different distinctions that the Re tries to offer in his explanation for why it is that some cases, the cases that we call Gerama, there's a P'tor, and in other cases, the cases that we call Garmi, there's a Chiv. But ultimately, right, vela kol kashet, tiher tatamei valabait atzmo irvanim peratav amai chayav to atzmo ino hezek mamon. So what the Tosfot is unsatisfied with this answer, but brings a counter example that we won't necessarily go into in depth right now. But there seems to be an example that of a case that right, that doesn't seem to really fit into the conceptual distinctions that the Re brought, and kind of out of that, Tosfot brings the Ritzvah's Shita, which is a totally different way of conceptualizing the distinction between Garmi and Gerama. Venir el Ritzvah. So the Ritzvah thinks the Dina de Garmi having mitam knas. So that Dina de Garmi it's not a totally different kind of case, or a different conceptually distinct from the cases that we call the Gerama, but the Dina de Garmi, right, the Din of Garmi is a knas that Chachamim are putting on a certain subset of these cases that are kind of Gerama cases, right? There are a whole slew of different kinds of indirect damage that can happen, and on some subset of those cases, Chachamim saw fit to hold the mazik liable, midin knas, right, which is and midin Rabbanit kidemuchach v'Yerushalmi ulekach kol hazek hamatzui v'haragil, right, hamatzui v'haragil lavo kansu Chachamim v'tam de kansu שלא יהיה כל אחד הולך מזיק לחברו והיינו תמה דמן וחי והזק שאין ניכר ואפשר בשוגג נמי כאן יצר יגמר. So, right, the cases that we are in which we hold the mazik liable in the Garmi, are the cases where there's the hezek matzoi v'haragil, right, v'haragil of, meaning it's not that there's a conceptual distinction between the kind of indirect damage in Gerama and in Garmi, but that hezek hamatzui v'haragil, right, that in cases that are just more common, right, those are the cases in which Chachamim saw fit to put a knas on the mazik, and that, right, that the cases that Chachamim saw fit to be kones the mazik, they could do even in cases where it actually happens b'shogeg, right, where it maybe would make sense not to liknos them, but according to the Ritzvah, there's low plugin cases like that, right, and that despite the fact that all of them are indirect damage of the same kind of conceptual type, the chiyuv in some of them makes sense, because that's just what Chachamim saw fit to do, right? So it's right. Dina de Garmi itself doesn't refer to a special class of cases. It refers to a mechanism, right, a legal mechanism through which Chachamim can enforce liability in the cases in which they deem it necessary. One kind of last point in the Meiri before we sum up is that the Meiri, he is closer in a manner that's sort of closer to the Shita of the Re, and also Chachmei Sfarad, who also try to find conceptual distinctions between the class of cases known as Gerama and the class of cases known as Garmi. He offers another conceptual distinction. So he says yesh lechazek behem, right? He's talking about right, the Re and Chachmei Sfarad shedavar zehu bichal din Garmi, right, v'lo bichal Gerama benizakin. Right, so that there's a particular case that is looks like, right, that is Garmi and not Gerama. שכבר ידעת שהרבה מפרשים טרחו ליישב מה הפרש בין דין דגרמי שהוא חייב ובין גרמה בניזקין שהוא פטור, right, what's the right, that many of the Rishonim have tried to come up with a conceptual distinction between Garmi and Gerama, עד שפירשו, right, and now we get the Meiri's distinction. So what the Meiri thinks Dina de Garmi is a case in which, sure, part of it is that the nezek has to be caused solely via the mazik himself and not via kind of external third parties. But also, right, that part of what makes something dina de Garmi rather than Rama is a case in which it is the intent of the mazik, right? That in the cases that we call Gerama there's might be a case in which there's a third party participating, but or it can also include cases in which this indirect damage was also unintentional, but indirect damage that is intentional, right? That's dina de Garmi, and those are that might be a case when we can actually enforce some kind of liability for the mazik. Right, so Garmi is damage that, although caused in a roundabout way, was done with the with the explicit purpose of inflicting damage. Right, so what we end up is really two sides of the two kind of teams within the Rishonim. Right, there's the shita of the Ritzvah. Right, the Gerama is not essentially different from Garmi. Right, Gerama is just indirect. All of these cases are under the class of Gerama that's indirect damage at all, any kind at all, and Garmi is just what we call those cases of indirect damage for which Chachamim saw a reason to enforce, right, to be mechayev, to enforce some kind of liability for the mazik. Whereas we get the Ri along with Chachamei Sfarad, who kind of build on the Ri's position, and the Meiri, which is that there is some kind of essential difference between Gerama and Garmi. The Gerama is really just indirect damage, and Garmi is damage that's either less indirect or somehow kind of there's a closer connection between the mazik and the nezek. Or it's caused with intent, but that there's really something that distinguishes the class of cases for which we do hold the mazik liable and the cases for which we don't. And now that we have the Ritzvah, I think we can go back and kind of add another sort of another box to our this spectrum in terms of how the Rishonim are thinking about the halachic perspective on damage caused via Gerama, right? According to the Ritzvah, the liability of dina de Garmi is actually a way of relating to those cases that are caused by Gerama. So sure, we have Rav Tavi Bar Machna who says that in Gerama cases, there's no chiyuv, there's no liability, but there is an assur and a requirement to distance oneself. We see the Marshal saying you're chayav in order to be yotzei shamayim. Maybe the Beit Din can put pressure on you. The Meiri says that you can be possible to eat it, and the Ritzvah says that actually, right, we see that in dina de Garmi that one of the things that Beit Din can do in cases of Gerama is actually to legislate liability in those cases. Or certainly in the cases that are most common, and cases in which it makes sense and is important to enforce liability.